So in the Vijay Kamble versus Customs Department, Mumbai, the applicant sought show cause notices and other document copies relating to certain proceedings that were being conducted before the Directorate of Revenue Intelligence. And the matter was currently under the adjudication of the Commissioners of Customs. He said he should be entitled to the said information because I think what the applicant suggested that he is actually involved in exposing fraud and corruption to the tunes of hundreds of crores of rupees. And this definitely is something that will cause loss to the public exchequer, and hence he should be allowed to get access to these show cause notices as well. What the applicant believed that there was a kind of a fraud that was committed on the exchequer to the tune of 67 crore rupees, especially to the Customs Department. And if he gets access to some of the show cause notices, then he will be able to help the state in exposing the fraud and the corruption. And that is the justification that he actually suggested for the information that has to be. The Customs Department denied the said information, and what they said was, though this information could have been treated as a third-party information, because the matters were before an adjudicating officer, it is for the adjudicating officer to decide how to call for those said information and how not to call for the said information. And to actually ask an RTI query during the intervention or trying to intervene into an ongoing judicial process will actually curb the independence of the adjudicating process. And hence the Customs Department denied the said information. And unfortunately, in this case, the show cause notices pertain to nearly 12 third parties. So 12 third parties had to be issued the kind of notices based on which probably final adjudicating process had to be taken place. So the full bench in this case had to take a call, and A.N. Tiwari, the Information Commissioner who decided this in 2009, clearly said that the said information is exempted under section 8(1)(h). He said that when a quasi-judicial proceeding is undergoing, the RTI Act cannot be invoked to access information relating to that proceeding. So very clearly, the intention of the legislature in section 8(1)(h) is to protect quasi-judicial proceedings, which necessarily cannot be rigged through RTI petitions. And this will be important to protect the impartiality of the quasi-judicial proceeding. It will help maintain integrity of the investigative processes, and not that the said information will not be provided, but it cannot be provided when the proceedings are ongoing. Once the proceedings are completed and any RTI that can be filed, the information probably can be shared at that point of time. So that is the judgment that was given in this case, and I think it deals with section 8(1)(h) in terms of quasi-judicial proceedings and the disclosure norms during a quasi-judicial proceeding. Next, if we go to section 8(1)(d), section 8(1)(d) deals with information which are exempted, which relate to commercial confidence, trade secret or intellectual property, the disclosure of which would harm the competitive position of a third party. Now, commercial confidence information or trade secret information or information that is in relation to intellectual property is exempted under the Right to Information Act under section 8(1)(d). Now, what is pertinent and important to note here, that once we start coming to section 8(1)(d), you will notice that this said information, that is commercial confidence, trade secret and intellectual property, are not absolutely exempted. Section 8(1)(d) says that though they are exempted, the competent authority may decide to disclose the said information in larger public interest if it so warrants, right? So I think some of this said information can be shared, some of the said information can definitely be given, as the case may be. Now, to explain the positions on the section 8(1)(d), we may probably look at the case of the Central Board of Secondary Education versus Anil Kumar. It's a case decided by the Delhi High Court in the year 2012. In this case, very interestingly, the Central Board of Secondary Education had actually moved from marks to a grading system, right? During that time, I think they have reversed this at some point of time, and from a grading system they have come to a mark system, right? Now, a father was very keen to know his daughter's marks from the secondary education board. So what he did was he filed an RTI petition to the Central Board of Secondary Education, and she had got grade like A2 and A1 in most of her subjects. For example, in English she got grade A2, and in social science she had received grade A1. So he was a concerned father, and he thought that the grading system did not adequately show what kind of marks his daughter had received. And he said that if he was given the kind of actual marks that his daughter has secured, this will actually help him identify her weakness in studies, and he could take timely action so that she can pursue a proper career after her grade 12. This was what the father had stated, and he wanted the actual marks to be disclosed. Now, the Central Board of Secondary Education declined this said information. They said, look, the very reason why it was moved from a mark system to a grading system, right, would be defeated if citizens were allowed to file an RTI petition and seek their marks, individual marks. So if the marks are anyhow going to be disclosed, why should the grading system be introduced? So the Central Board of Secondary Education referred to the National Policy on Education 1986 and the Program of Action in 1992, which recasted the examination system and suggested that grades be used in place of marks. Interestingly, the National Curriculum Framework of 2005 also envisaged a valuation system which would grade the students on their regular activity in the classroom and enable students to understand and focus on learning gaps. And the board also said that the introduction of grades in examination had been debated for a long period of time, and a countrywide consultation had also taken place among eminent educationists and experts, and the 9-point grading system had been introduced in the secondary school examination from the year 2010, right? So the system of declaring subject-wise marks had thus been replaced by subject-wide grade or grade points. The purpose of introducing the grading system was to take away the frightening judgment of the quality of marks, to lead to a stress-free and joyful learning environment, and was intended to minimize misclassification of students on the basis of the marks, to eliminate unhealthy cutthroat competition, and to reduce societal pressure. The order denying the information as to the marks was thus justified by the Central Board of Secondary Education. Now, interestingly, when the matter came before the High Court, it was argued that when we talk about grades and marks, there is no specific mention under the Right to Information Act that the said information should not be provided for, right? Because it is about a candidate seeking his own marks. It is not me seeking somebody else's marks. So in her interest, shouldn't this marks be disclosed? What is wrong if she was given this marks? Because it's not something that is disclosed in the public domain. So I think in the interest of transparency, in the interest of improvement, the marks could have been disclosed is what was argued in this case for the disclosure of the same. So the court in this case said that, look, you cannot read the RTI Act in isolation. The RTI Act makes a very delicate balance between disclosure norms and non-disclosure norms. And the whole grading system was to preserve the confidentiality of the marking system. That was the whole purpose of the grading system. Now that the grading system was introduced, preservation of confidentiality is important. It is important that students don't get caught in the mark race, as the case may be. And I think in achieving the purpose of RTI, where transparency and accountability is very important. However, whether there is a public interest requirement to disclose, the court said no, there is no public interest requirement to disclose. Right? So they said that RTI cannot be allowed to circumvent those kinds of policies in which there is a necessitation to preserve that kind of said information. In this case, the kind of marks that the candidate had actually got, and hence I think the grading system continues, and citizens probably would not get the right to seek individual marks, and clearly the grading system prohibited the disclosure of individual marks, and that was the very purpose. And to maintain that purpose, I think RTI cannot be used to circumvent and seek that individual marks. I think those were the concerns that were addressed in this case. Now let me read a paragraph from this case that I have extrapolated and put it in the slide. The High Court said, in achieving the objects of transparency and accountability of the RTI Act, other equally important public interest is to preserve and confidentially maintain sensitive information. This cannot be ignored or sacrificed under the RTI Act, and that it has to be ensured that the revelation of information in actual practice does not harm or adversely affect other public interest. Right? So RTI should not affect other public interest of confidentiality of sensitive information. Thus, the court said, disclosure of marks which though existed but were replaced by grades was not allowed purposefully, and not literal interpretation of the RTI Act was advocated. Right? So this is what the court held in this particular matter. So I think it's a kind of an important observation from the Delhi High Court, and it's kind of an important denial, keeping the grading system and its object in mind. Also, in the case of Bhagwan Lal Seth versus the Bank of Baroda, it's a case decided by the CIC in 2009. The CIC observed that apart from commercial confidence, there is also a fiduciary relationship between the banks and the customer. So before providing the said information, the bank has to check the public interest, and hence the bank may refuse to provide information if the bank's it would lead to a breach of trust, and it would lead to a breach of fiduciary relationship or the competitive position of the third party. So I think banks also have a duty to keep information in commercial confidence, and they cannot disclose information regarding their clients or their customers, because it may affect the competitive position of those third parties as well. So some of these institutions very clearly have a mandate to deny the information under section 8(1)(d). Coming to section 8(1)(e), which very clearly exempts information which is available to a person in his fiduciary relationship, again unless the competent authority is satisfied that larger public interest warrants the disclosure of the said information. So information that is received in a fiduciary capacity is also exempted under the Right to Information Act section 8(1)(e). Now one will definitely observe and see that the fiduciary relationship is a concept which applies in those cases where information is received between those kinds of persons who stand in a close relationship with each other. This could be a relationship between a banker and a customer, a doctor and a patient, a guardian and a ward, and so on and so forth. So I think while it is very relevant to understand where and how fiduciary relationship operates, it is something that very clearly allows a person holding such information not to disclose the said information under the Right to Information Act. The plea of fiduciary relationship is advanced by several regulatory bodies, right? However, please note, fiduciary relationship is not keeping the information in privacy and confidentiality. It is information that is held as a trust, in trust of another party, and that information, ordinarily there is an obligation to protect the said information. However, please note, sometimes this information that is held in a fiduciary capacity is not completely immune from the scrutiny of the public authorities. So the said information will have to be shared. Right? So there is nothing like an absolute duty to protect the said information under the term fiduciary capacity. However, in this case called Subhash Chandra Agarwal versus CPIO Supreme Court, the Apex Court held that the purpose of exemption is to permit screening and preservation of confidential and sensitive information made available in a fiduciary capacity. Right? So that is what the Supreme Court held in that case. And I think the Supreme Court very clearly wanted to state that there are instances when such information can be held in a fiduciary capacity.